Assalamualaikum and a very good day to Dr. Sam and also my fellow classmates. So my group and I will be presenting about question number 1, which is whether defense of fair links can create a new copyright in a derivative work. So my group consists of me, Nur Aida Nadira Hussein, Nur Sofia Maisara Nordin, Siti Nur Ashikin binti Zakaria, Nur Amira binti Ibrahim, and also Anis Kamilia binti Yusaimi. Without further ado, I'm going to present the introduction part. So what is fair dealing? Fair dealing is a right that have been given to a person in order to use a copyrighted work without having to get consent or permission from the author itself. So the action of copying or referring to other works will not be regarded as infringement of one's right. So by virtue of section 13 clause 2 sub A of Copyright Act 1987, it stated that the doing of any acts by way of fair dealing, including for the purpose of research, private study, criticism, review, or the reporting of news or current events, does not infringe copyright in literary, musical, or artistic work, a film, a sound recording, or derivative work. So which means when the work itself is relating of this purpose of work, then it will not be regarded as infringement. According to a learned judge in the case of Media Corp News Limited and Media Bank Johor Bahru Sdn Bhd, it highlighted that when considering a work to be a fair dealing, the court need to look at the purpose of the work. So there are 4 requirements that need to be looked, which are the first one, characteristic of the work, the purpose of the work, nature of the work, and also the amount of fair dealing that has been included in the work itself. So if the purpose of the work is for criticism, review, or comment, then it can be regarded and considered as a fair dealing. So it is important and crucial to consider the use of them and the purpose of the work before considering the work as fair dealing and being protected under Copyright Act. Next, what is derivative work? So basically, derivative work is a work that is derived from a pre-existing work. So it is considered as copyrighted work even though it is merely as the same as the original. For example, there is a novel or book that is wrote in the Malay language, then someone want to translate it into a French language or Tamil language, then he can do so. So the act of translating into another language is not considered as infringement of one's right, but it is protected under Copyright Act. So however, there are conditions and requirements that need to be fulfilled in order to be regarded as derivative work that protected under this Copyright Act. So that's all from me. I will pass the presentation to Sofia and Maisara.
Assalamualaikum, my name is Sofia. My matric number is 264230. Now I'm going to continue with types of fair dealings. The first one is research. According to New Oxford English Dictionary, research is a systematic investigation into a study of materials and sources in order to establish facts and reach new conclusions. The scope of research is being stated under Section 13 Clause 2A of Copyright Act 1987. Before amendment, research only covered non-profit research. However, after the amendment, research covered both non-profit and profit research. The example of case in the Canada Law Book Incorporated and Law Society of Upper Canada, the plaintiff brought an action against defendant on the ground of copyright infringement for giving service of request-based photocopy, where the legal materials will be reproduced by the Law Society staff upon the request by the law service members, judiciary, and authorized researchers. The court held that the defendant's activities not infringe the copyright protection because it is fair dealing for the purposes of research and private study. So from this case, we can see that the court gave a wider interpretation for the research purpose and not limited to private or commercial context. Moving on to the next case, in the Media Corp News and Media Bank Johor Bahru Sdn Bhd, where the defendant contend that the dealing with the plaintiff new programs were qualified for non-profit research since the compilation of the segments of the programs were done without any charges. So the court held that the segments produced by the defendants using the plaintiff's television news excerpts for the clients is in a sizable profit and not considered as a non-profit research, thus the defendant fails. So we can see that the court has distinguished their decision in these two cases because the court strictly applied the scope of non-profit research stated under Section 13 Clause 2A. The court will look the defendant's operation or activities as a whole and not only a part that constitute as a non-research purpose. So for the academic research, the court will look whether the research made fall under the meaning of Section 13(2)(a) of the Act and try to balance between the owner's right in copyrighted work and user's right. So the question now, who is eligible for this fair dealing? It is only available for the person conducts the research only. However, the court cannot simply dismiss the defense based on Section 13(2)(a). The court must take into the consideration whether the defendant's activities fall under the ambit of the research and whether the research is in conflict or interfere with the owner's copyrighted work through the exploitation of the work made. Moving on to the second type, which is a study. The study must be a private study where it gives benefit to the individual that owns the copyright work which relates to the educational or academic purposes. In the case of Creative Technology Limited and Artstyle System Limited, the defendant made a reverse engineering for the sound card contained in the plaintiff computer programs to ensure it is compatible with what was available in industry. So the court held that the private study should be strictly construed for those who are performing the study. The court added that the defense is also not covered for commercial purposes. So we can see in this case also, the court applied a strict approach in determining whether it is covered as a fair dealing or not. So since the defendant used it as for commercial purposes, then it is not construed as a fair dealing. And the last type is the criticism and review. So criticism is estimation or assessment of qualities and character of copyright. Meanwhile, review is an appreciation of criticism of work. So the commentator can make a review or criticism by and support their work by extracting arguments or evidence from another copyrighted work as long as it is necessary and relevant for the criticism purposes. So what is covered under this scope is linguistic, artistic and literary style and contents of thought that have been expressed in the work. So in the case of Pro-Sieben Media AG and Carlton UK Television Limited, the plaintiff brought an action against the defendant for copyright infringement as defendant had included a 30-second sequence of film from a program made for the plaintiff through the defendant's broadcast for television series about checkbook journalism. The defendant argued that the extract used in the series was a fair dealing as it was for criticism or review purposes. The court held that the fair dealing applied to the defendant's action of using plaintiff film for the criticism purposes. So it is a fair dealing under this scope and the defendant succeed. So now I'm going to pass the presentation to my another groupmate. Thank you.
Assalamualaikum and hi, my name is Anis Kemilia binti Usaimi. My metric number is 265137. Moving on to the next part, which is types of derivative work. Under Section 8 Clause 1 of Copyright Act 1987 stated about derivative work. Derivative works such as translation, adaptation, arrangement, and other transformation of works eligible for copyright are protected as original work. So this section will be focused on three types of derivative work, which are translation, adaptation, and arrangement. The first types of derivative work is translation. For example, there is one book that been wrote in English. Then later it translated into other language such as Malay. This type of work will be protected under copyright. This can be referred in the case of Longman Sendirian Berhad against Pustaka Delta Pelajaran Sendirian Berhad. The facts in this case was the defendant brought out their book in 1980, where the general arrangement, language, features, and also errors were similarly to the plaintiff book that was produced in 1979. The act of the defendant causing the plaintiff to suffer loss. The help was the court granted an injunction to the plaintiff, and the defendant was liable for infringement, as the book that plaintiff produced was original and protected under copyright. Second types of derivative work is adaptation. For adaptation, the example is in literary works. Adaptation can be in form of adapting a novel into a drama or movie, like we usually see on television, where it creates a dramatic form from a non-dramatic works. The case that we can refer is Short Music International and Co. against Colossal Record of Australia, where the first respondent authorized in the making of a disc, which was a techno dance music adaptation from a work known as Excalibur, which contained 4 remix tracks of the chorus of the applicant's work who owned the copyright. The court dismissing the application as the Excalibur adaptation does not debase the work. Last but not least, the third types of derivative work, which is arrangement. Example for arrangement, when a song with a rock genre going through change in arrangement, and then the genre change into jazz, as there is a different instrument played. Generally, arrangement change an original song by inserting different notes or applying different instruments.
Next, I'm going to present factors that need to be fulfilled under fair dealing. In order to balance the exclusive right of a copyright owner, the Copyright Act 1987 provides for certain acts which copyright owner has no right to control. The fair dealing exception stated under Section 29 and 30 of Copyright, Design and Patent Act 1988, where it allows others to use a people copyright in the matter of first, purpose for research and private study, second, for criticism, review or quotation, and third, for the purpose of reporting current event or news reporting. The first factor is purpose and character of fair dealing. The focus on the function of copied material being used, the issue used to create something new or merely copied into another work. There must be a restriction where it is used for a limited access only, so that the number of readers can be controlled. Thus, the chances for the material to be copyright is minimum. In the case of Kelly against Ariba Soft Corporation, plaintiff is a professional photographer, alleged the defendant, Ariba Soft Corporation search engine, which infringed Kelly's photograph. Defendant operated a visual search engine with a lower resolution thumbnail, copies for display on research result page. The issue here is whether the defendant display of thumbnail version on internet search engine constitute as fair use. The court held that the defendant reproduction of plaintiff photos as thumbnail images was fair use. The second factor is nature of copyright work. This is to examine the characteristics and qualities of copyrighted work. The author had a right to decide the condition on the first publication, when and how to make the work freely accessible. In the case of Salinger against Random House Incorporated, the defendant collaborated to publish J.D. Salinger biography, who is a well-known author. The defendant quote and paraphrase several of Mr. Salinger unpublished letters without authorization. The court held that the defendant unauthorized infringed act were not permissible fair use because the letter was unpublished. The third factor is the amount of dealing. This amount refers to how much infringement of copyright work. The larger the taking, the less the fair dealing. In order to consider the amount of the part taken, the court will look at the quality and quantity of the material. This can be seen in the case of Campbell against Acuff Rose Music. The fourth factor is the effect of use upon the potential market. This is related with the potential market for the work that was copied. Consideration of this element is meant to strike a balance between the value that the public will reap if the use of potential market is allowed and the personal advantage that the owner of copyright will receive if the use is denied. This can be seen in the case of Rogers against Kunz.
Okay, Assalamualaikum. My name is Siti Nur Ashikin Binti Zakaria with the metric number 265019. And on this part, I would be presenting and discussing the relationship between the elements of copyright and derivative work under the Copyright Law 1987. So basically, when we are going to discuss the correlation between the derivative work, also the protection of copyright, there are three main prerequisites to explore. The first one is originality, the second one is fixation, and the last one is qualification. So in discussing the origin of originality, there are two facets of originality can be derived. The first one is the work must be presented through an exercise of skill, labor, also with judgment. And the second one is that the works may be regarded as original if an element of skill, labor, and judgment have been expanded in their creation. So one of the cases have been quoted is on the case of Victoria against Pacific Technologies Australia Pty Limited. In this case, the court held that a literary work may be expressed in print or writing irrespective of the creation, whether the quality or style is high. So also along with this case, the court held that there must be some work involved in the production of a literary work, meaning to say there must be some added value to the original work. Only that if it has been satisfied, then one can claim to be the work to be copyrighted. Okay, moving on to the second prerequisite, which is on the elements of fixation. So accordingly, in understanding the elements of fixation, Section 7, subsection 3b of Copyright Act 1987 provides that a literary, musical, or artistic work shall not be eligible for copyright unless it has been written down, recorded, or otherwise. So to provide a clear picture, in 1997 amendment, it had been contended that the term of fixation refers to the embodiment of sounds, image, or both in a material form. So if one wants to claim their work to be copyrighted, then they need to transfer their work into a permanent one. This had been stipulated in the case of Macmillan and Company Limited against Copper, where the court held that the position of an abridged work may be copyrightable if it had been supplemented with the new creation also had been transferred into a new and tangible form. And the last element to be fulfilled in order for a derivative work to have the right under the copyright protection is the element of qualification. In this element, it has been contended that one new work, or merely a new work cannot be copyrighted. However, if the new copyright owner wants to obtain an exclusive copyright, she or he need to identify the work which is derivative. For instance, he wants to do a translation, so she need to prove that on what matter does the translation is a new one. This had been contended also in the case of Stowe against Thomas, whereby the issue arises is whether a copyright owner could stop another person from translating her work without her authorization. So in this case, in providing justice to the aggrieved party, the court, in assessing justice to the party, contended that the defendant may be protected by the plaintiff. Thus, the plaintiff, who was the owner of the original work, was eligible to file a claim towards the defendant because the defendant has merely translating her work into a new one, and there is no issue of a new value has been added. So in overall, we can contend that we can see that there are three main prerequisites for a derivative work to have the right under the copyright protection, which is the first one, he need to prove that there is an element of originality, fixation, and qualification. Thank you.
To conclude, defense of fair dealing can be said as creating a new copyright in a derivative work. The act of copying others' work and include it in that particular materials will not be regarded as infringement of one's right. So it is allowable and permissible by law as long as it is complied with the 4 requirements and condition, which are the nature of the work, the purpose of the work, the characteristic of the work, and also the amount of work that included in that particular materials. So if the author itself failed to satisfy these conditions and requirements, therefore his works or materials cannot be considered as copyrighted work. Thus, it shall not be protected under copyright law. So fair dealing can be used as a defense after proving that these 4 requirements and conditions are fulfilled by the author. So yeah, that's all from my group. Thank you.